Hello everyone, and welcome to this video tutorial on how to apply the law on privity of contract to a contract law scenario. In this tutorial, we're going to be looking at the Carlo and the Burley Builders mini scenario. We're going to recap the law on privity so that it's fresh in our minds so that we can look at how to use that idea structure to get a really nice answer to this question. So as always then, let's start by looking at the situation that we've been given. So the situation is this. Carlo contracts with Burley Builders to work on his house. Daisy, his neighbour, gives violin lessons in the evening. So Carlo makes it a term of the contract with the builders that, quote, all work should be finished by 5 p.m. so that neighbours are not affected by noise. In fact, Burley Builders frequently work until 7 p.m, and on several occasions Daisy has had to abandon her lessons due to the noise. To apologise for the disturbance, Carlo buys tickets to take Daisy to see a concert at the Royal Theatre. Unfortunately, the theatre has sold too many tickets for the concert, and Carlo and Daisy are unable to see the performance. Daisy is very upset about this. And you're being asked to advise whether Daisy can successfully claim directly against the builders for loss of earnings and against the Royal Theatre for disappointment. So we can see here in this particular mini scenario, we've got two issues going on, the upset with the builders and the upset with the theatre. And you're being asked to say whether Daisy can sue the builders directly and whether she can sue the theatre directly. Now, although this question doesn't mention the word privity, I'm hoping that if you'd got that in the exam, you would have known straight away that this is about privity of contract. Because when you look at these two situations, the person who's made the contract is Carlo. So Carlo contracts with the builders, Carlo contracts with the theatre, and you're being asked whether Daisy can enforce those contracts. And this is all about privity. And privity, if you remember, is like saying privacy of contract. And we know that the doctrine of privity of contract is a common law principle which provides that a contract can't confer rights or impose obligations upon any person who isn't a party to the contract, i.e. Daisy. The premise is that only parties to contracts should be able to sue on them. But over the years, we've seen that there are lots of exceptions to the general rule on privity that means that Daisy might be able to enforce these two contracts directly herself, even though she didn't make them. So this would be a logical point for us just to do a quick recap on what the law on privity is. So on this slide, we've got a summary of the key things that you need to know about privity of contract. Remember that there's also a separate video tutorial in which I go through all of the law and all of the cases in detail on privity of contract. So it might be a good idea to go away and watch that again before you come back to try and apply the law on privity. But a quick recap then. So the general rule is what we always start off with. And the general rule of privity of contract is that only the parties to a contract can enforce its terms. A third party cannot, except in exceptional circumstances, which we'll look at, enforce a contract to which it's not a party because it has no rights in respect of that contract. And that's shown in Tweddle and Atkinson and also in Dunlop. And if you remember in Tweddle, it was two dads who were contracting to leave some money for a groom. They sadly died. And the groom couldn't enforce the contract between the two dads because he was not a party to it. Similarly, in Dunlop and Selfridge, there was a contract between two parties, Dunlop and Selfridge, and it was ruled that a third party couldn't sue Selfridge over an agreement as to the price because that third party was not in a contract with Selfridge. The court decided that there was no contract between the third party and the others, so it did not have the right to sue on that contract. So this privity rule shown in these two cases means only those who are a party to a contract have the right to take action against another party to the contract. However, This rule of privity can cause disadvantages, including a degree of unfairness and inequity to third parties in some cases. So a number of exceptions to the general rule have emerged. The most important one for us is the Contracts Rights of Third Parties Act 1999. There is an exception to the general rule on privity if goods are lost at sea, and that's shown in the case of Dunlop and Lambert. But the focus of this scenario we're looking at today is actually the Contracts Rights of Third Parties Act. Under this 1999 Act, a person who's not a party to a contract has the right to enforce some terms of the contract in specified circumstances. The contracting parties can incorporate limits and restrictions on this under the contract if they don't want a third party to be able to enforce it. And this is going to be really important, as I've said, in Daisy's case. And because it's important for us today, I'll just skip back to this slide on the Contracts Rights of Third Parties Act. So it is an exception to the privity rule, and it means that a third party, such as Daisy, could enforce the terms of a contract that she's not party to if one of these situations applies. 11A, if she's specifically mentioned, or 11B, if the contract purports, meaning seems, to confer a benefit on them. And as I've just said a minute ago, if the contracting parties don't want a third party to be able to enforce it, they can write that in there. But we can't see that in the mini scenario that we're looking at. So just a quick refresher there on the 1999 Act, which we'll come back to. A summary here. So we've just looked at the 1999 Act. There are other statutes which create exceptions to the privity rule, such as the Married Women's Property Act and the Road Traffic Act, but these they're not very important now because we now have the 1999 Act. We also have collateral contracts, as in Shanklin Pier. Is where a contract may be accompanied by a collateral contract between one of the contractual parties and a third party. So if the third party makes a collateral warranty or a promise upon which the formation of the warranty depends, then a party to the original contract can sue on that promise. That might appear in some scenarios, but it's not in our one with Daisy today. There's also agency and trusts, but again, they're not so relevant to us today. So let's go back to Daisy's situation then. Now we've had a quick recap of the law. So we've got these two situations, and students sometimes find privity a bit challenging. So I've done a little diagram here to show the first situation. So Carlo has contracted with Burley Builders, and part of the contract says that the work should finish at 5 so as not to disturb the neighbours. Now Daisy is a neighbour, but she's not a party to this contract, so the normal rule on privity using Tweddle, using Dunlop, means she's not part of that, so she can't sue on it. However, we've just had a bit of a recap of the 1999 Act, and as a neighbour we can say that although she's not mentioned specifically by name, you can't see her name Daisy in there so that it's 11A, but the contract seems to purport a benefit on her so that a neighbour is not affected by noise. Well, she is a neighbour, so under the 1999 Act, she might be able to enforce that contract directly with the builders. The second situation in that scenario I've done as a diagram as well. So we've got Carlo buys 2 tickets for the theatre. Again, Daisy is not a part of that contract. She's over here. The general rule of privity of contract means she can't enforce this contract. However, and this one's not as clear, maybe her only chance of enforcing this directly against the theatre would be under the 1999 Act. Maybe she could argue that under 11B, because there are 2 tickets, seemingly you don't buy 2 tickets for one to go to waste, one should be a benefit of someone. However, it's unlikely she's going to be able to use this, I think, because she's not named or described, whereas in the contract with the builders, it said neighbour and she was a neighbour. But that's something we could possibly argue here with the theatre. But the best option would be Carlo to sue the theatre on her behalf. And let's look at how we apply the law on privity using IDEA so you can get a nice answer to the question. As always, we IDEA. So we identify that the claimant, and then in this case it's Daisy, Daisy wishes to enforce the contract between Carlo and Burley Builders and between Carlo and the Royal Theatre. Daisy is not privy to these contracts, so the rules on privity need to be discussed. You then define what privity is. So it's the rule that only parties to a contract can sue each other, Tweddle and Dunlop. And then we explain all of privity using our cases. So you're basically writing out your summary sheet, but in full sentences. And then we apply the law. And when you're applying privity, you're always starting off by saying the general rule is they can't enforce it, Tweddle and Dunlop. And then you have to look back at these exceptions and think, can your character rely on any of them? And for Daisy, her only option really was the Contract Rights of Third Parties Act. In other scenarios that you get, there might have been promises, about how long paint would last, things like that, that look similar to cases we've studied. And in which case you'd be starting off with the general rule, they can't enforce the contract, but then you'd be applying collateral contracts to your situation. I've done a bullet point answer to the Daisy scenario on my next slide. It is a bit small, so you might want to pause the video here so that you can have a read of it. It's very listy, very bullet pointy, just so I could fit it all on one slide. But remember, in the exam, you need to be writing fully, nice full sentences and explaining your cases clearly. So I've identified that Daisy wishes to enforce the contract, which is between Carlo and the builders and Carlo and the theatre. She's not privy to them, so we need to look at the rules on privity. I've defined privity. I've explained privity using my cases. Obviously, I would explain what happened in the cases. I'd give detail on the Contract Rights of Third Parties Act. And then I've got into my application. So Daisy has no privity with the builders. She wasn't party to the contract. But it does seem to give her rights under Section 1(1)(b) of the Contract Rights of Third Parties Act because it mentions neighbours and she is a neighbour. She then doesn't have privity with the Royal Theatre because Carlo purchased the tickets. Carlo could claim damages on behalf of both himself and Daisy, and I think that would be the best option here. We could plausibly argue that the contract seems to give a benefit to a third party because if you buy 2 tickets, inevitably someone should be benefiting it. However, the absence of a name on a ticket would be an obstacle to this requirement, so it'd be better for Carlo to sue on her behalf. So she can enforce against the builders, but she can't probably enforce against the theatre. So I hope that was helpful to you in looking at how to apply the law on privity. I do recommend that you have a go using the IDEA structure on as many little mini scenarios or bigger scenarios on privity as you can, so that you can practice applying some of the other exceptions as well as the Contract Rights of Third Parties Act.